Okay, let's settle down and now turn to a stimulating conversation about Delaware. Over to Robert.
It is very not encouraging that that was a laugh line. I'm going to remember that. So I'm Robert Miller. I'm a professor of law at the Scalia Law School at George Mason. I am moderating today, and I'm also going to be the fourth speaker. We're going to be telling you about developments mostly in Delaware, but also importantly related ones in the federal securities law. One of my colleagues said that this is probably the time of highest turmoil in business law in his career, and I'm even older than he is, and I could probably say the same thing. So there is a lot to talk about, which will be very interesting to us, hopefully to you as well. We have great speakers for you. In the order in which they will present, first we have Mohsen Manesh on my far left, who is the Mr. and Mrs. L.L. Stewart Professor of Business Law and an Associate Dean at the University of Oregon School of Law. Then Eric Chaffee, closest to me, who is the John Hutchins Professor of Law and also an Associate Dean at Case Western, where he also heads a business law center and a center on compliance and risk management. And finally, third, we have Itai Fiegenbaum, who's an assistant professor of law at St. Thomas University in Miami, and then me. So we're going to start with Mohsen, talking about federal securities law.
Thank you. Is this on? Can everyone hear me okay? It is? Okay, great. Well, thank you, Robert, for inviting me to be on this panel, and thank you to my co-panelists and for all of you for joining us today. I'll start with a general observation that echoes what Robert just said, which is that for those of us who study and practice in corporate and securities law, we have the distinct privilege of living through one of the most interesting and dynamic periods in the history of our field. Not since at least the 1980s have we seen so many settled questions, long dormant, reopened for debate. And that's true at both the state level and at the federal level. At the state level, we're witnessing reinvigorated competition in the market for corporate charters, a market that's long been dominated by Delaware. In response, the state has rushed to enact not one, but two significant sets of corporate law reforms to stave off competition from the likes of Nevada and Texas. Meanwhile, at the federal level, President Trump's return to office has meant new leadership at the SEC. And this new Republican-led commission has come out guns blazing, targeting long-standing flashpoints in federal securities regulation as part of a broader deregulatory agenda to make IPOs great again. That's a quote from the commissioner himself, or from the chair of the commission. What I want to do today is to use one of the SEC's principal reform initiatives to illustrate these larger dynamics, the agency's campaign against frivolous securities class actions. The vehicle for the agency's reform here is shareholder arbitration, and what's happening with arbitration is a case study in how shifts in federal policy and state-level competition are reshaping corporate law in real time. Now, by shareholder arbitration, I'm referring to a provision in a public company's charter or bylaws that compels shareholders to arbitrate their claims rather than litigate them in court. The widespread adoption of arbitration provisions would eliminate shareholder class actions. In their place, shareholder claims would be channeled into individualized arbitration that, for the vast majority of investors, would be economically irrational to pursue, even for meritorious claims. For these reasons, the SEC has for decades opposed shareholder arbitration. But in September of last year, the agency abruptly reversed this long-standing position. The agency's reversal on arbitration represents a seismic policy shift. 1 month later, speaking before members of the Delaware Corporate Bar, the new SEC Chair Paul Atkins demanded that Delaware's policymakers follow the SEC's lead and repeal its state-level ban on shareholder arbitration provisions. This demand puts Delaware in an extraordinarily awkward position, and it illustrates the two-front pressure that the state now faces. For context, Delaware has not one but two statutory bans on shareholder arbitration provisions. DGCL Section 115A, which was enacted in 2015, prohibits arbitration of state corporate law claims. Section 115C of the DGCL, which was enacted just this past summer, prohibits arbitration of federal securities claims. What's notable is that neither of these statutory provisions actually mentions arbitration. Instead, both statutory bans emerged as legislative byproducts of Delaware's attempt to regulate forum provisions. In enacting each ban, Delaware's lawmakers were responding to developments in case law concerning where shareholders could bring certain claims. And in each case, the ban on shareholder arbitration was merely a collateral consequence of the state's efforts to regulate corporate forum provisions. But while both bans share this incidental origin, they rest on very different policy foundations. Start first with Section 115A, the state's ban on arbitrating state corporate law claims. Delaware will never voluntarily repeal this ban. The reason goes to the very heart of Delaware's lucrative corporate law franchise. The value of Delaware corporate law, the reason for Delaware's dominance, is the Delaware Chancery Court, its expertise, its efficiency, and crucially, its regular production of new precedents. New precedents, in turn, are the lifeblood of Delaware corporate law. They ensure Delaware law remains nimble, updated, and adaptive to changing market dynamics. They create network effects that make Delaware law attractive compared to other states where judicial precedents are scarce. If shareholder disputes were to migrate from the Delaware Chancery Court into private arbitration, new precedents will cease. Delaware law will stagnate. The very facets of Delaware law that have historically made it attractive will suddenly disappear. For this reason, arbitration has been aptly described as an existential threat to Delaware's corporate law enterprise. Therefore, Delaware will never voluntarily repeal Section 115A's ban on arbitration of state corporate claims. Section 115C, however, the ban on arbitrating federal claims, is fundamentally different. Delaware has no comparable interest in federal securities claims. Federal securities claims do not generate Delaware precedents. They do not develop Delaware corporate law. To the extent Delaware had any policy justification for banning their arbitration, it was to align Delaware law with federal policy at a time when the SEC opposed shareholder arbitration. But that justification evaporated when the SEC reversed its anti-arbitration stance. Thus, Delaware now faces exactly the kind of two-front pressure I described at the outset. The SEC is demanding change, and with Nevada and Texas actively courting public companies, any corporation seeking to impose arbitration on its shareholders can simply incorporate elsewhere. Delaware is powerless to stop this. So my conclusion here is that Delaware will preserve and defend its ban on arbitrating state corporate law claims, but it will readily surrender its ban on arbitrating federal securities claims if market participants demand it. So then the real question is whether the market will actually want arbitration for shareholder claims. On this question, I believe the conventional wisdom is mistaken. Despite warnings that the SEC's policy shift has opened the floodgates, there are real reasons for skepticism that public companies will actually embrace shareholder arbitration. To begin with, investor sentiment decisively points against arbitration. Institutional investors and proxy advisors have consistently opposed it. Indeed, every time a public company's shareholders have been presented with an arbitration proposal, they have rejected it decisively. But what's more striking is that corporate managers themselves have shown little enthusiasm for imposing shareholder arbitration. From Alphabet to Pfizer to Johnson & Johnson, every time a public company has faced a shareholder arbitration proposal, management has opposed it. This managerial reluctance suggests that corporate leaders recognize what academics and defense lawyers alike have long suggested, that arbitration may actually be less preferable for corporate defendants than the current system of class actions. Why might that be? Well, first, class actions provide a predictable, law-governed process that arbitration cannot match. Courts apply precedent, follow evidentiary rules, issue reasoned decisions, and are subject to appellate review. Arbitration, by contrast, offers none of this. Instead, arbitration has been described as essentially lawless. Arbitrators are not bound by precedent, need not explain their decisions, are not required to apply rules of evidence, and their awards are nearly impossible to overturn even when plainly erroneous. Second, class actions provide procedural safeguards that screen out weak claims. The Private Securities Litigation Reform Act's heightened pleading standards, automatic discovery stays, and lead plaintiff mechanism, these features narrow disputes and prevent duplicative shareholder actions. Arbitration, however, lacks these filters, allowing claims with dubious merits to survive longer and to generate settlement pressure. Third, and perhaps most importantly, class actions centralize disputes and deliver finality. A class-wide settlement binds all investors, extinguishing all claims in a single resolution. Arbitration does the opposite. In arbitration, separate claims are proceed independently before different arbitrators, each applying their own standards. This fragmentation invites inconsistent rulings, generates duplicative discovery demands, and forces corporate defendants to manage parallel proceedings with no mechanism for global resolution. There would be no peace in arbitration, and the emerging threat of mass arbitration, that is the simultaneous filing of hundreds or even thousands of individual arbitration demands aided by plaintiff-side law firms, only amplifies these risks. Given these drawbacks, it's unsurprising that even before Delaware's statutory bans were enacted, no public company judged shareholder arbitration sufficiently worthwhile. And that's true despite favorable Supreme Court precedents dating back decades, and despite the SEC having limited power to stop a company that is already public from adopting an arbitration provision. So let me conclude where I began. We're living through a remarkable period of flux in corporate and securities law. The arbitration story is a window into the larger dynamics at play. At the federal level, long-established policies are being reversed, and at the state level, Delaware's dominance is being challenged. Caught between these forces, Delaware is going to be forced into making some strategic choices, defending some positions while abandoning others in order to remain competitive. For arbitration, I expect that Delaware will preserve its ban on arbitrating state corporate law claims. That prohibition is essential to its lucrative corporate law franchise. But if companies demonstrate meaningful demand for arbitrating federal securities claims, I expect Delaware will readily abandon Section 115C in order to remain competitive. History suggests that demand for arbitration will be modest, but even modest demand may be enough for Delaware. In this respect, the future of shareholder arbitration and the continued viability of shareholder class actions will be dictated not by Delaware law, but ultimately by the markets. Thank you.
Great. So thanks for the invitation, Robert. You hope when you enter the academy that bright people invite you to be part of their important conversations.
And you got me, so.
You're being overly modest. And thanks to FedSoc for having me. I am moderating a panel after this, so if I run out at some point to go to there, it's not meant to be offensive to the importance of the panel. So I want to back up a little bit and start where Mohsen actually started with where we're at in regard to thinking about DExit. In regard to it, ultimately we know there's been a migration from Delaware to other jurisdictions, Texas, Nevada. There's been some push from other states. Oklahoma jumps to mind. To in fact try and get more people to incorporate in their particular jurisdictions. Some of that has been a pushback on increasingly onerous regulation in Delaware. Some of it's been fueled by Elon Musk. And the Delaware legislature has tried to correct. This has happened before. The reason why we have the Massachusetts Trust, which is the commonly known business trust that's out there that's used for a lot of mutual funds, is because it's reaction to corporate law being too onerous. Before Delaware, there was New Jersey, and as New Jersey law became more onerous at the end of the 19th century, beginning of the 20th century, everybody shifted to Delaware. Ultimately, in regard to this, currently we've seen a lot of different action, a lot of different turmoil, as Robert referred to it at the beginning of the discussion. In regard to that, I take what is sort of a majoritarian approach to things. I actually think that's a really good thing. And there are other people similar to me out there who think similarly about this. Jeremy Kidd, for example, who's sitting in the back of the room, I know has similar opinions. Ultimately, I think that this turmoil actually is a good thing. So I've not really ridden in this particular place yet. But at the same time, a lot of it is just figuring out which song to reference. Do I go with Blue Oyster Cult and Not Fearing the Reaper? Do I go with REM and It's the End of the World as We Know It, but I Feel Fine? Or do I please my daughter and say that we should just let it go and the cold doesn't bother me anyway? All of these things, I'm not really concerned with the outcome of the individual discussions, although I find them interesting and I do think they are important. What I like is that we're coming back to having a real race for corporate law, which has not existed for a very long time, and I think actually is a wonderful thing in a whole bunch of different regards that I want to talk about. So the reasons for the majoritarian opinion, I think it's always good to explore basically why people think the way that they do. I think that there are people out there that think Delaware law is sort of the end of history where everybody should arrive in regard to corporate law. I don't believe that because, certainly corporate law has evolved over time. There's been this rise of shareholder protection and stakeholderism in Delaware and a lot of other jurisdictions that I think that, academics at least find appealing. In regard to that, I think that, it's easy to be happy when you're winning. We should be concerned about factions and when they become too powerful. And I also think that there's this joy of complacency, meaning predictability for businesses, and also, I teach trust and estates in addition to business law. There are lots and lots of splits there. We're just not used to that in corporate law. We're used to, taking the wrapper off of most case books, and there just being mainly Delaware law there. So, as corporate law scholars often, in my own case, I'm just not used to talking about splits in authority, despite the fact that they can be very, very exciting. In terms of thinking about the reasons that I prefer the race, there are a bunch of different ones. One of them relates to legal diversification. Kelly Alsace-Williams in 2013 wrote an article in the Columbia Law Review where she talked about that in addition to all sorts of diversification you can think about in terms of where to invest, what to invest in, we ought to be thinking about the legal regimes that govern things like legal entities. That's important because I think that, if we just have one system of corporate law and we only think about corporations, if there's some sort of mistake that becomes unattractive to investors, there's real systemic risk there. So we have to be concerned about that. In addition to that, if you really are interested in investor protection, you do want there to be real diversification, that whole Harry Markowitz modern portfolio theory. Diversification reduces systemic risk, smooths returns, manages volatility, captures broader opportunities and cushions, systematic shocks. The fact that we may have a competition for corporate law, in fact, may actually be good for investors. Certainly, there are merits to having a market for law. We know that there are merits to spontaneous ordering devices, showing my Austrian economic roots here. Knowledge and discovery about preferences, the promotion of entrepreneurial innovation, better resource allocation and efficiency, disciplinary force, the importance of individual choice, all of those things come into play. If you want a practical life example of why exactly spontaneous ordering is a good thing, you probably ate here very well in New Orleans. When you go to your airports, it's not going to be good because it's a captured market. It's one of those things where you have competition in regard to the law, better ideas come about, we end up better understanding what people's preferences are in a really, really complex market, in terms of thinking about where to incorporate securities, all of those things. I'm excited about the fact that there are these new business courts popping up. We've seen a lot of legislative intervention in Delaware, especially recently with SB21. I actually like the common law. It's evolutionary in nature. It tends to be more efficient, and as a result of that, there really are things to like about the fact that there's existing corporate law in Nevada or Texas or wherever that ends up with a new business court. And we're going to see what courts do with that and how exactly that evolves beyond the Delaware system. And then, there's also just generally this concerns about factions, Federalist 10, that sort of thing. Delaware has a lot of power, and there's a question as to why Delaware. And it's a great state. It's fun to drive through. It's the first state, I believe. But at the same time, similar to New Jersey, making it, really the place where corporate law is found, where corporate law begins and ends, there are genuine problems to that. And having real competition means that we won't see the same complacency that we've seen out of Delaware in the past few years. And in addition to that, some bravado that probably has not been terrifically healthy for corporate law as well. Are there, arguments against what I'm saying? Certainly there are. This is going to create some instability. Businesses don't like uncertainty, similar to law professors. And, as a result of that, some of these business courts are going to need to be created if they can be. Oklahoma, for example, can't because, ultimately they're unconstitutional in that jurisdiction. And then we're going to have to learn about statutes that may be substantively different than Delaware. There will be shareholder protection concerns. I probably shouldn't say this, but I think this is probably the right crowd. I'm not that concerned about it. I mean, if I want to go over to the casino and risk my kid's college fund, I ought to be allowed to do it, even though it's not a great idea. And frankly, through tuition remission, maybe I'll do that. But ultimately, in terms of thinking about this, I do think that we have to be worried about fraud, preventing it, making sure that those sorts of things don't happen. But if there is the ability through this to create new risks or to create new opportunities, new law, some risks to shareholders I think ought to be tolerated. And ultimately there are things to like about the Delaware law. It does provide stability. There are certainly aspects of it, the availability of certain shareholder suits that are well structured, as Mohsen told us about, can be very good things about it. And this does create some risk that we will throw out the baby with the bathwater, so to speak. So, in regard to this, and in terms of thinking about what business law scholars really ought to be doing if they like this race, I do think that we ought to be thinking more broadly about whether or not we're teaching enough of the splits in authority in regard to law. Are we talking enough about what's going on in Nevada, what's going on in Texas? Are there, certain business entities that we're not talking about? Business trusts don't come up in the standard BA book, despite the fact that they're used for asset securitization really quite regularly. And I've talked to business law scholars, and they've been like, "What's a business trust?" And then suddenly they realize that a lot of the mutual funds that they have are formed behind them. I think that we need to celebrate the experimentation rather than, it seems like in most instances when I talk to corporate law scholars, and not pointing to anybody in this room or even conversations with anybody in this room, there's this real fear of any sort of change. I think that we ought to be having really deep, meaningful discussions about what can be done better, and really just generally encouragement of innovation rather than trying to drive things back to Delaware. But thank you for listening, and I think I'll leave things there.
Thank you. Thank you for having me. Good afternoon to everybody. I will be discussing SB21 and specifically the role of the Delaware courts, or even more specifically, how they allowed the doctrinal drift that resulted in an overturn of established precedent. So first of all, a few words about SB21 for those of you that are not Delaware scholars. That is the most recent and significant amendment to the Delaware General Corporation Law. This was a massive event in the world of corporate law. The amendments overturned well-established case law that took Delaware decades to create. And the manner in which the SB21 was enacted, I think, is as significant as to the content of the amendments themselves. Traditionally, Delaware is lauded for being even-handed in creating corporate law. There is a committee that is comprised of well-established seasoned attorneys, both from the plaintiff's bar and from the corporate bar, the defense bar, and they come together and they usually come to some type of agreement which they provide to the Delaware legislator to enact the law. And this was emphatically not the case for SB21. The amendments were, the argument is that they were steamrolled by, let's say, by the governor's office, and they were provided mostly, the plaintiff's bar was not provided any input, and the input that they tried to seek was not accepted. So that's just one of the issues of SB21, and the scholarship has started to engage with SB21, and of course you'll hear about the takeaways. I have a specific focus. Mine is on the Delaware judiciary, and specifically how they found themselves in this situation in which their decades of case law was overturned without, in my opinion, abruptly and without too much warning. And I raise this question because the Delaware judiciary is known for its sophistication. This sophistication has several aspects. First of all, they know their stuff. They're corporate law experts. Nobody thinks differently. But there's another aspect. They're also known to have institutional awareness. And what I mean by institutional awareness is that they are cognizant of Delaware's role, of its prestige, of its status, of its place in U.S. corporate law. And because of this institutional awareness, they usually do not take measures that might harm them, that might risk their role. Delaware's hegemony, of course, it provides a lot of money for the state, and there's also a very well-developed legal infrastructure that feeds off the Delaware franchise. So how did this happen? How did they screw up? Arguably. So there's this persuasive scholarship out there which explains how the institutional awareness operates, how it manifests. Specifically, the scholarship shows that institutional awareness manifests in a way to stave off risks to Delaware's franchise. And I'll give you an example of how this happened in the past. I'm taking you back to 2008. This was the subprime mortgage scandal. If you remember, banks were failing right and left, and this was a big deal. The feds were getting involved. There was some banks were described as too big to fail, and they were going to be bailed out by the federal government. One of these banks was Bear Stearns, and the way that Bear Stearns was supposed to be saved was by it being acquired by J.P. Morgan. J.P. Morgan was set to acquire Bear Stearns. The acquisition was structured as a merger, and in a merger, the target shareholders have to approve, which is usually great, but it also poses some risk. What if the Bear Stearns shareholders said no? Then the federal bailout will fail. In these types of situations, these deals have deal protection mechanisms, deal protection devices that are supposed to protect the deal from not following through. So in the Bear Stearns J.P. Morgan merger, what the parties decided on was, let's simply make J.P. Morgan a shareholder, and not just a shareholder, but almost 40% shareholder. They're issuing them an immense amount of shares. This will allow J.P. Morgan basically to vote in favor, push the deal through, eliminate all risk. Sounds great, but there's one small problem. This issuance of shares probably violates Delaware law. It violates the rules on and the doctrine with regards to how much you can bulletproof the deal. And so this, sure enough, shareholders sued because of they sued in Delaware court, and this comes to the Delaware chancellors, and the Delaware chancellors were in a pickle, because if they ruled on the merits, they might invalidate a deal that the feds really wanted, and so they have to follow precedent. So what did they do? In this instance, they pleaded comity. They said there's a parallel claim in the New York courts, and we will stay the Delaware claim. We'll take it out. We'll take it off our hands. We won't deal with this. And this is extremely out of character for Delaware courts. Usually, when a Delaware incorporated corporation is sued in Delaware, they will follow through and they will adjudicate the lawsuit because they have a vested interest in adjudicating Delaware corporations. So, and in this issue, they said no, we're taking a step back. And I think this, and it pains me to call it a historical episode because it's 2008, but it is it pains me very much. But this I think we have two takeaways from this episode. One, Delaware judges are sophisticated. They don't want to. They understand their role. They'll be wary about making judgments that might harm the franchise. And two, they understand where the harm might come from. And in this case, and this is from the accepted scholarship, the harm might come from the federal government. If they do something wrong, if they step on some toes, then Congress might intervene, and they might legislate additional measures that take away from Delaware's position. And this was in 2008. Sarbanes-Oxley was fresh in their minds, right? They knew that this might come. And I bring this episode to show you the general framing of of the risks that Delaware faces, and specifically to show you that controlling shareholders are not part of the accepted narrative. They're not part of the framing of the risks. And I think this explains Delaware's doctrinal drift. Maybe Robert will go into this in more detail about the doctrines that Delaware adopted and expanded that led to harm specifically to controlling shareholders. And my thesis here is that because controlling shareholders were not an accepted part of the narrative of U.S. corporate law, they weren't identified as a risk, then Delaware judges, they didn't understand the magnitude of the risk that they faced. And I think this is what happened, and it eventually led to SB21, and we'll see where it goes from here.
So as you may have gathered, a lot has happened in Delaware in the last couple of years. But if there's one event, one case that sort of is, rules them all, one case to rule them all, right? That is without a doubt the Elon Musk compensation case. And I know many of you probably know something about it, but the key facts are basically this. Back in 2018, Musk is running Tesla. He's CEO. Like all CEOs, he gets a big comp package. And his package is expiring, so he needs a new one. He's earned out everything he can get on the current one. He needs a new one. And, he's Elon Musk, right? So, he says to the board, guys, I got a great idea. Right now, the company is worth $45 billion. That might sound like a lot of money to you, but it isn't to Elon. Elon thinks big. And he says, here's what we should do. If I can increase the value of the company by $50 billion, so more than double it, and by the way, at this point, General Motors isn't even worth $50 billion. If I can increase the value of the company by $50 billion, you give me stock options that are worth 1% of the company. And I won't do it once. I'm going to do it 12 times over. So for every time I increase the value of the company by another $50 billion, you're going to give me another about 1% of the company. So the end of the deal was there are these 12 payments he can get. For each one, he has to increase the value of the company by $50 billion and meet some other hurdles, which are not all that important. And if he hits all 12, he'll take the value of the company from $45 billion to around $650 billion, and he'll end up with shares that, through various adjustments, end up to be around like 9 or 10% of the company. Well, everyone says, this is insane, Elon. You're not going to take a $45 billion company and turn it into like the largest company in the world or close to it at the time. And he's like, watch me. All right? So the board approves this. Right? It's sent out to the shareholders. They approve it by about a 70% margin, 70, 71% will vote in favor. Elon not voting his 22% of the shares that he already had. And of course, not only does he increase the value of the company, he has 10 years to do it, but by year 6, the company isn't worth $650 billion, it's worth over $1 trillion, okay? So he hits every one of the, every one of the milestones, he gets the full pay package, okay? But a shareholder brings really a plaintiff's lawyer, Greg Varallo is his name, representing a shareholder, brings a lawsuit challenging the package, right, saying it's unfair to the company. Okay? And, I think most people looking at this would say, come on, the shareholders approved it. The shareholders got, close to $1 trillion in value. This guy wants $50 billion. I mean, would you pay $50 billion if someone gave you $600 billion? I would, okay? Most shareholders thought it would work, okay? And it gets litigated. And the result turns out to be the directors who thought they were independent who approved this, they weren't really independent. Elon controlled them. The disclosure the shareholders got that looked pretty adequate to most people, nope, wasn't good enough. That didn't work either. And when we scrutinized the actual substantive terms of this transaction, it was unfair to the company. Result, Elon needs to give the whole 65 billion back, 56 billion back, and you know what he's going to get in return? Nothing, because probably that was the fair number. Now, Elon's reaction tweeting out on X was, you know, never incorporate in Delaware. Okay? And this starts, you know, the real push for DExit. There are other cases and other problems, but this is the one that, you know, really gave it wind in the sails. Okay? Now, at one level, all right, I think the problem with this case is, you know, look, this is America. Right? As Eric just said, if you want to be an idiot and risk your money in a casino, you're allowed to do that. Okay? And this is also America, which means that if you don't like something, you're allowed to sue for it. Okay? But this is all, we are in Delaware. And in Delaware, the great thing about the judges is not just that they, you know, know a lot about corporate law and are very financially sophisticated and write very long opinions and are wonderful because they cite law professors all the time. And so, right, what's really good about Delaware is these people have some sense, okay? And they should have looked at this and said, you know, come on, the shareholders approved it. Maybe the disclosure wasn't absolutely perfect, but the whole thing has to have been fair, okay? And that is not what we got. The chancellor voids the package. At which point Elon's like, okay, here's what we're going to do. We're going to resubmit it to the shareholders. And we are going to tell them everything that happened, and we are going to even attach to the proxy statement a copy, Chancellor McCormick, of your 204-page opinion telling the shareholders everything we did wrong and ask them to approve it again, which they do by an even higher margin. Back in Chancery Court, nope, that didn't work. Still voided. All right. This is what really prompts SB21 because there are provisions in SB21 that overturn the key holdings in this case. All right. Now, so if you go from the big picture of like Delaware courts seem to have lost their sense of reality on this case, right, down to what doctrinally went wrong, the answer there is, I think, kind of interesting from a jurisprudential point of view. So that's what I'm going to finish talking about. Okay? This happened once before. Back in 1985, in what is one of the most important cases in Delaware law, is a case called Smith versus Van Gorkum. And you all might have read this in law school. And what happened in Smith versus Van Gorkum is that Delaware, this company called TransUnion, sells itself to Jay Pritzker, a takeover artist. And then they get sued for not having, you know, done a good process, not having gotten a good enough price. And everyone agrees that all the directors were honest, none of them were making an illicit buck, all of them acted in good faith, okay? Which for the chancellor below was quite enough to say, good enough for us, deal goes through, directors were honest, shareholders approved, right? At the Delaware Supreme Court invents what had not existed before, no matter what they say, a duty of care. And saying that although you were perfectly honest, although you guys didn't make an illicit buck on this, you didn't use enough care in approving this transaction. Therefore, right, you are going to be liable for the difference between what you would have gotten if you had conducted a good process and the price you actually got. And that number looked to be probably on the order of $60 million. Chump change for Elon Musk, but to, you know, 11 individuals in 1985, the 11 independent directors, that was a lot of money. They were all facing personal bankruptcy over this. Okay. The reaction was the directors and officers insurance market collapsed overnight, and the Delaware legislature moved in and said, no. If you want, as a corporation in Delaware, to eliminate personal liability of your directors for breaching their duty of care, you may. And every corporation in America has. Okay? So the lesson was this. The lesson was you can't have a rule that results in people who have been honest, who are not making an illicit buck, who think they've done the right thing, ending up with immense liability that will, you know, in the corporate context, the numbers get big pretty quick, right, can bankrupt them. Right? If you look at the Elon Musk case, the court ordered rescission of the package and told Musk give back the stock, or the stock options, right? They also could have said, you know, no, we're going to order damages. The damages are the difference between the 56 billion he got and whatever was a fair number. I don't know, maybe that was 36 billion. Right? So that's a $20 billion damage award, and we're going to tell the independent directors they have to pay it, or Elon and the independent directors jointly and severally, right? Now, Elon can fund a $20 billion judgment, but those independent directors, they can't, right? One of them is a billionaire, maybe two of them are billionaires, but only like a billionaire once over. They don't got $20 billion like Elon Musk does, okay? So it would have been the same thing. You would have had these independent directors at Tesla who, you know, the court agrees, they acted honestly. They thought this was a good idea. They thought it was in the best interest of the shareholders, and they were right. They didn't make an illicit buck on it. Elon got the money. They didn't, okay? They were honest. They didn't make an illicit buck, and now somehow they're being told, you know, you're on the hook for 20 big ones. Well, those are billions, okay? So how did we doctrinally get into this place? The answer is that Delaware's rules on controlling shareholders have, in my opinion, some people disagree. Travis Laster has a 100-page article saying this is wrong, but I think he's wrong about this. Delaware law moved quite significantly in the last 25 years. Okay? 25 years ago, a director would be challenged for being not independent. You're in the pocket of the controller. Okay? And you know, if you were a family member or a romantic partner or an employee, yeah, you were in the pocket of the controller. But there were plenty of cases which said, well, you know, you've been in business deals with him in the past. You go to the same social clubs. You've been at some of the same weddings. You have business and personal relations. I think you even played golf together last week. Okay? This sort of thing, you know, in 2022 and 2024, the answer was that doesn't make you less than independent. The fact that you hang out together. Okay? And then 10 years later, Leo Strine says, yes, that's right, but you know, there could be some friendships that are almost like being family members. You imagine two people, they go to college together, they're college roommates, they're they're maids of honor at each other's weddings, and then, you know, they go on vacation with each other every year, their families go on vacation together every year, they think of each other as sisters, right? That could be the functional equivalent. Like, yeah, okay, I guess that could happen, right? By the time we get to the Elon Musk case, the chancellor is saying, well, this director, he didn't go to Elon's wedding, but he went to his brother's wedding. You know, no, it wasn't the best man, just went to the wedding, okay? And we actually get things like, well, this guy went to, you know, Elon Musk's kid's birthday party. Do you know how many children Elon Musk has? Do you know how many birthday parties there must be? Come on, I mean, there must be thousands of people, right? You know, and now suddenly you're not independent for this reason. Right? And then it gets even worse because it's not just, you know, your status, what was your relationship with Louis Musk, but, you know, during the negotiations, we don't think they pressed back hard enough. You know, Elon, you know, got busy and stopped the negotiations, and then when he, you know, wasn't busy anymore, they recommenced. This kind of shows that Elon was in charge. We think, you know, you were all in Elon's pocket, right? That was one crazy thing, right? There was similar creep as to, you know, who was a controller. Once upon a time, to be a controller, you needed either more than 50% of the shares, or, you know, a lot of shares and things that showed that you had in effect more than 51% of the shares. In one famous case, a 49% shareholder said to the directors, you have to do what we tell you. We're the 49% shareholder, right? So that wasn't literal mathematical control, but it was pretty close, okay? Elon had 22% of the shares, right? Elon's bargaining power did not consist in the 22%. It did not consist in some other contractual rights he had. It consisted in this. If they didn't give him what he wanted, he'd say, fine, run your own electric car company. I'm going to Mars, all right? And he'd have gone over to SpaceX, okay? Like, screw you guys, I'm going to Mars, right? That's what he would have done, right? That was his bargaining power, his ability to walk away, okay? That does not make you a controlling shareholder, that makes you a very talented manager, all right? So there was this creep about who's independent, this creep about who's a controlling shareholder that, you know, all comes together in the Musk case. There's a whole other thing of when do you apply entire fairness? Is it only on freeze-out mergers, or is it other transactions with the controlling shareholder? And all these things, a bunch of different strands, all come together in the Musk case. And SB21, the 2025 amendments to the Delaware General Corporation Law, changed this stuff They changed a lot of other stuff, which I'm sure probably might not needed to have been changed, but they did change this stuff, okay? And it was, at least in my view, this creep about independent directors and scrutinizing them more clearly and who's a controller and so on. And if you want to know what's really wrong with that at the end of the day, in my view, it's something Richard Epstein says in the Simple Rules for a Complex World book. He says, it's the quest for cosmic justice. We the courts, we're gonna get it right in every last case, okay? You know what? I love the Delaware courts. No one is more pro-Delaware than I am. I hope that they win the competition. But, you know, even I think there are a lot of things that keep the world going correctly in the corporate law world other than the Delaware courts. There's the market, for example, right? There's, you know, people's reputations. There are a lot of other factors, and it is these that you should rely on a lot, not always Delaware judges scrutinizing everything in every detail. Who went to the birthday party? All right. Thank you very much. All right, we're going to let the people up here respond to each other a little bit, and then we're happy to take some questions. Does anybody up here have something to say?
So I have a question, and maybe it's for you, Itai, and you, Robert. You both have accounts, one that Delaware courts didn't appreciate the political power of controlling shareholders as a constituency, another that there was just creep, and these were both causes to SB21, and that may be true. Neither account, though, I think, satisfies me as to what was the triggering event. Why now, and why so rapidly for SB21?
Well, do you want to take that, Itai? Or I have a thought too, but go first.
Oh, well, I think it, the triggering event, I think Musk probably is the triggering event, but it was brewing under the surface. Robert mentioned the cases against Elon Musk. There's another very famous billionaire that also finds himself in Delaware courts quite often. You might, the owner of Meta Corporation, you might have heard of him, and I have a feeling, people of that stature, they don't enjoy being too much in Delaware courts. It's not always just having to pay billions of dollars. It's also what I refer to sunlight overload. When there's a claim against them, well, Delaware makes sure that there's information rights, and then make sure that that the plaintiff will have a great deal of information, and some of it is not very. Let's say that these very powerful controllers are not happy with that amount of information, and they have the power. Well, now we know they have the political power to change that.
So I think it's also there was just bad luck in unfortunate circumstances. So there's the 2024 amendments, and then there are the 2025 amendments. So it's the 25 amendments that are aimed at the problems going on with controlling shareholders. But the 2024 amendments were really very needlessly contentious and in a very un-Delaware thing to have happen. People said nasty stuff about each other. And I think that sort of poisoned the atmosphere. The 2024 amendments were mostly about overturning a case called Mohsen. Lots of people, including me, and I think maybe everybody, or a lot of people on the panel at least, think Mohsen was correctly decided. Okay? The problem is that the traditional rule in Mohsen is probably not the greatest rule we need. So what should we do? We should have the legislature change it. Okay? And if this had been cast as, oh, well, yes, this is the traditional Delaware rule. It's now very clear. We want to change it. Okay, right? But for a lot of people, it came out as, this decision by Vice Chancellor Laster is just terrible. No, it was basically right, okay? You want to change the rule, but that doesn't mean that the court got the rule wrong. The court got the rule right. That was the traditional rule. And then unfortunately, once people started attacking the judges literally responded with public advocacy about their cases. And that made it a lot of really bad feelings. And then at that point, right before the 2024 amendments, the Musk case drops in January 24. And if the whole 2024 thing hadn't happened, it was just old Musk by himself, I don't think it would have been anywhere. It'd have been bad, but it wouldn't have been this bad. Other stuff. So I got a question for the panel, but I think it's mostly for you, Professor Manesh. If you go to Texas, right, and you incorporated in Texas, if you want to bring a derivative suit, so you have a plaintiff who's going to bring a claim saying the board did something wrong, like, approve Elon's comp package, you have to hold, is it 3% of the shares?
Something like that, yeah.
3% of the shares. In Delaware, you just need a share, okay? The plaintiff in the Musk case had 9 whole Tesla shares, okay? But in Texas, you need 3% of the shares. 3% of $1 trillion company is quite a lot of money, okay? So what this basically means is, if we move to Texas, derivative suits are not going to be brought by plaintiffs' lawyers who have a stable of clients who each own a microscopic piece of any company they need to sue on. It's going to be that you're going to have to go out and find some big shareholders like Vanguard and so on, maybe even assemble a coalition of them to get a group together so that collectively they have more than 3% of the shares and so on. So there's going to be this gatekeeper function of large institutional shareholders have to be willing to sign on and fund the derivative suit before we even get one off the ground. Is that a good idea or a bad idea?
The Texas rule?
Yeah.
Derivative suits have long had their critics, and the Texas rule certainly takes one whack at the problems associated with derivative suits by making it virtually impossible for shareholders to bring it unless you really have buy-in from large institutional investors. As a practical matter, I can't imagine Delaware adopting that kind of rule just because, as I said earlier, Delaware is so reliant on its production of case law, and you would see no derivative case law again if Delaware were to adopt a provision like that. Whether that's good or not, that Delaware would never do something like that. I suppose I take Eric's position, which is let 1,000 flowers bloom, and let's see how it goes, and markets can correct and investors can make choices. It's certainly the case that if you invest in a Texas corporation, you're never going to have a derivative action against the managers of that corporation. And in Delaware, the opposite is the case, although those derivative actions are controlled by the plaintiff's attorneys and not the investors themselves. And so I suppose as a policy matter, I'm skeptical of the Delaware, or excuse me, of the Texas rule, but I'm not troubled that Texas has adopted that rule because Delaware has a different rule, and we can see which one does better.
I want to see what happens. The other thing is, there are other policing devices beyond derivative suits. So, I don't know the answer to that. I think it's a great question. I want to know the answer to it, and I think that it's worth allowing that competition, as was suggested, to actually see which is the better rule, and then we can work from there.
Well, I'm not against allowing the competition. I just have hopes as to why, because I'm so lazy. I don't know if I'm learning anything about Texas law.
I believe I mentioned that in my list of reasons why people.
I know, and you looked at me when you said it too. So I was down in Texas at A&M doing a conference on Texas Business Court, and I learned a lot. They're very interesting people, very smart. They're trying very hard. There's a lot of good things in Texas. But I read the Texas Business Judgment Rule, and in Delaware, that's, you got to read a whole bunch of cases, but in Texas, it's statutory. And frankly, it wasn't all that well drafted. It was kind of unclear, and I'm not sure what that means. So I asked one of the organizers of the conference, who's a partner at Gibson, Dunn and Crutcher in Dallas, right, and a Texas lawyer, and spent his whole career in Texas. An older guy, someone he should know, right? And I said, what does this mean? He said, oh, no one knows. I said, why? He said, they've never been litigated. I said, the business judgment rule has never been litigated? He said, well, you got to understand, there only are 5 public companies in Texas. We got Southwest Airlines and 4 microcap companies. Not a lot of litigation, even apart from the derivative thing, right? I said, wow. He said, well, but that's okay. When Tesla reincorporated from Delaware to Texas, the proxy statement you had to give the shareholders had to compare Texas against Delaware. So they must have analyzed it there. I said, oh, that's good. So I pulled this proxy statement to read what Elon Musk's lawyers said about the Texas Business Judgment Rule. And they said, well, in Delaware, they summarized the Delaware Business Judgment Rule. They said, but in Texas, and then I read what that said, and it was a quotation of the statute that I couldn't understand the first time I looked at it. This is a very real thing you're talking about. Very real.
This is why people like to be incorporated in Delaware. They can at least approach and understand the law.
Yeah. All right. We have questions from the audience before we? Yes, please.
I have 2 questions.
Yeah.
Over the years, they've developed Corwin and Lynch and MFW, and all these cases, they've kind of built this kind of beautiful Delaware law, and then SB21 comes in and says, like, we're a safe harbor. What do you think survives? Because it claims to be a safe harbor, but it seems like it's kind of bulldozing the establishment. And then the second question is, if we get a diversity of jurisdictions in which there's only a limited number of corporate law cases that are going to happen each year, if they get spread out among more jurisdictions, does every jurisdiction get worse? Because we don't have a core amount of just Delaware law. Like now Delaware is producing less because some are going to Texas, some are going to Nevada. So does the race make Delaware law worse as well? And then we just never really get outcomes, or we just have to wait longer? Sorry.
Can I answer the second one?
Yeah, take the second one.
Yeah, I love the second one. I teach in Florida, and I make it my mission to focus only on Florida law. Florida law is heavily influenced by Delaware. If you see any Florida case, they will cite Delaware, and I have to continue to flesh out this idea, which is great. But I have a feeling that Delaware law will continue to exist outside of Delaware and expand outside of Delaware. So I think that answers to question number 2. Delaware, there's scholarship, there's some debate about what exactly SB21 overturns, whether, if you read the blogosphere, whether Corwin exists, MFW, that's a different debate. I think they live in jurisdictions which still provide for some type of shareholder litigation. So this is for Eric's project. We have to find those little spots, and those jurisdictions will allow corporate law to prevail.
Yeah, I mean, I think the jurisdictions are still going to talk to each other, and even beyond that, I mean, for example, really in terms of the race you're talking about, incorporation in other jurisdictions. Florida, for example, has a lot of incorporations in it. Edwards yesterday was talking about it, I think using statistics from Andrew Verstein. Ultimately in regard to this, I think that, historically what we've seen is one jurisdiction becomes sticky, and maybe Delaware wins, and I would be perfectly fine with that, but I want to see some competition here. I want to see a market, I want to see, the shaking up of things, and really, us learning from that and understanding it, and some new innovation to happen that, really is the things that people want, new efficient rules.
So I guess what I would say about it is the positive network effects that have been discussed, I think indicate that, yeah, great, there should be competition for this, but I think this is a winner-take-all market because of the network effects. I think it tends to be that way. It's been that way for an awful long time. It was New Jersey first, winner-take-all, then it's been Delaware, winner-take-all. So Texas can make a run at Delaware, or Nevada can make a run at Delaware, but I think it will end up as a winner-take-all.
The counter-narrative to that is that the market is going to be one in which there's segmentation, where some jurisdictions will lean more heavily on investor protection, while other jurisdictions will lean more heavily on managerial discretion, and some will try to find the average between the two. Delaware historically has probably tried to balance those two interests, but it's clear that some jurisdictions like Nevada and Texas are moving towards managerial discretion, and there'll be companies for which that might be a better fit, or at least they think it's a better fit, and so there might be product segmentation. On the question of what survives, shareholder litigation. I think SB21 was not well drafted, and there are still a number of questions about what it does or does not overturn in terms of the precedents, and when the safe harbor exactly attaches. So I anticipate that there will be no shortage of litigation around the new statutory text.
I think you make a really good point, right? If you look at the relatively small 10 or so companies that have left Delaware to go to Texas, they're almost all controlling shareholder companies, right? So if you're a controlling shareholder, yeah, you might want to be in Texas, right? If you're a public company with no very large shareholders with a normal public company board, you're not going to Texas, at least not yet, at least not on the basis of what's happened yet. As to what survives, you got to see what happens, right? I mean, part of this same creep, right? So there's this thing in Delaware called MFW, after the name of a case. It always sounds like some very improper expression to me, but MFW, all right? And if you do jump through the right hoops, the MFW steps, then you would get business judgment review, which means it's basically impossible for shareholders to challenge it, but you had to do the right steps. And so if you were going to do a transaction, you either do the MFW steps and you get low review, or you don't do them and you get really searching review. That was always your point. It was always your choice. And when MFW first came out, it's a controlling shareholder thing that would want to use it. Controlling shareholders don't want to use it. It was like, oh, great, we'll do this MFW stuff and so on. And then what happened in case after case after case is that the shareholders would challenge it, and the controlling shareholder would say, hey, man, I used MFW, I'm good. And then the Delaware court would say, well, you tried to use MFW, but you messed it up. So guess what? You're getting the search and review anyway, right? So MFW like always resulted in you paying a lot of money in the hopes of, getting low review. So what would happen is you'd pay a lot of money and you'd get searching review. And what basically happened in the market is the people said, well, this is just ridiculous. Let's just, not do MFW, ram the thing through however we please, and take the searching review. We're going to get it anyway, right? So one of the things that SB21 does, hopefully, is it pulls back on that creep too. So if you want, SB21 MFW, if you go down that road, you should really get it, right? That's one thing I would hope to say. Yeah.
Yeah, I'm a little skeptical about the threat of this competition for Delaware, how real it is. But let's assume that it's real. Here's my question. Years ago, the chairman of the Federal Reserve, Dr. Arthur Burns, coined a term called race to the bottom. What do you think is the danger of race to the bottom if you have various state corporation laws vying to capture Delaware's share of the market?
Race to the bottom and race to the top is a venerable topic in corporate law. I have thoughts, but I bet you all do too. What do you think?
I just want to see the race. I mean, frankly, markets aren't evil, people are. So as a result of that, I'd like to know what the revealed preferences are. Going back to the past question, and maybe implicated by yours, I mean, I do think, or a couple of questions, I do think part of the reason why we saw the Musk case is that there was a lack of humbleness amongst the Delaware judiciary. I mean, there were other decisions that could have been made there that were more splitting the baby, more reasonable, and they chose what was a very aggressive approach that, ultimately, was a bad look for Delaware, as Robert described very well, but also, created a threat to basically incorporations there. And I think that, even if this is just a threat, maybe what it does is it brings judges a bit more back in line in terms of making modest decisions. As to whether or not there ends up being a race to the bottom or a race to the top, I mean, realistically, we're talking about markets here. They're just choices, and you have to make those choices for one reason or another. One person's race to the bottom is a race to the top, and the other is another person's race to the top. So, I'm not that concerned about that.
The very famous Jensen and Mecklin article makes the point that under reasonable assumptions, including a decent efficiency in securities markets, if you go public with your company and you put in place provisions, or you opt into a jurisdiction that has provisions that allow you as the controller to take advantage of your shareholders, the market will price that in, right? And it all comes out of the controller's hide up front. Now, it gets more complicated if you start off in one division and jurisdiction and you move to another, but I think this is another way of making Eric's point that the market should really protect you here. If you want to, look, we know this, right? If you take your company public with an A/B structure, so like Facebook, where the founder has these high voting shares and has absolute control over the company, even though he doesn't own a majority in economic interest, he has a majority of the votes, but not a majority in economic interest. Those shares always trade at a discount to shares where that's not the case, right? So even, Mark Zuckerberg's done a pretty good job with Facebook, right? But everybody's worried, he ain't gonna be around forever. What if he gets crazy? What if he, stops doing Facebook and wants to invest in this artificial intelligence fad? What could possibly go wrong, right? So, those types of things, we know the market discounts those things. Yeah.
I just want to ask, if you think about each jurisdiction in the United States as a choice of jurisdiction in corporate governance, have you ever think about like adverse selection? Like it doesn't really mean like if you choose this jurisdiction, at the end of the day, it doesn't mean the good quality, it just ended up the bad quality.
Well, some people feel that way about Nevada at the moment. I mean,
I don't know if you have any idea about the implication of the adverse selection
So the riff on Nevada, I don't know if this is correct. I haven't looked at the Nevada statute, but the riff on Nevada at the moment is that it really eliminates a lot of duty of loyalty sort of things, duty of loyalty protections for shareholders. Does anyone know more about this than I to describe it?
I don't think so. I mean, Ben Edwards is the person to talk to about this from UNLV.
So, Nevada already kind of has that, right? For a long time, Pennsylvania, still to some extent, but nowhere near as much as in the 80s and 90s, had this absurd set of shareholder protections that were really designed to protect management against takeovers, okay? Nobody went into Pennsylvania for during that time.
And there's no stampede to Nevada now,
Right.
which suggests that this may not be a concern. As to the concern of, I'm likewise skeptical that the Delaware is facing real competition, but to the extent it is, and that could lead to a race to the bottom, which is completely subjective. There's always going to be the federal backstop, and it's true that under the current regime, there's a deregulatory agenda, but that won't always be the case, and to the extent corporate law does drift in a direction that is adverse to investor welfare, I think you will see federal intervention at some point. Maybe not today, but we'll have a change in political control eventually.
Yeah.
I was wondering if you could comment and perhaps give us an update on Carney versus Adams and the political balance requirement of the Delaware judiciary. I know the Supreme Court dismissed it for lack of standing, but I think that there's now a consent decree. Is that correct? And I wonder if Delaware being a blue state is that may no longer require political balance, or maybe I'm wrong on that, but whether that is, perhaps a concern to some companies if they think the judiciary is going to be, yes, independent, but very, very blue judiciary. Could you comment on that? And
Yeah,
tell
so-
me the update on
all right,
the status of that. What's
The first thing I want to say is that's constitutional law.
Different panel.
That's the politics.
Yeah. It is, but the politics, I think, of it is that this is not a red versus blue thing. Okay, the former Chief Justice in Delaware, Leo Strine, greatest corporate law judge of his, the generation. Okay, Leo and I disagree about everything politically. Okay, he's looking for the next New Deal. Okay, he is a man of the left. Okay, but on corporate law, Leo and I agree on almost everything because
Is that true of the younger people, though, that are going into corporate law?
Lori Will. I don't know what her general politics are, but I agree with Lori Will about almost everything. I agree with Bonnie David, one of the other young chancellors, about everything. Young. I was at an event with her the other day, and I mentioned I graduated from high school in 1988. She said that was the year she was born. It's horrible when the judges can do that to you. It's bad enough when the students do it, right? So it's not really red versus blue. I don't know exactly how to describe it, but I wouldn't describe it as red versus blue.
Sorry, go ahead. Well, I'm sorry, I don't have an update on Carney versus Adams. But I disagree here. I do think that because Delaware is a solidly blue state, Texas has used that as a cudgel. I was at a panel yesterday and I was asking, well, what is Texas exactly trying to compete for when it tries to compete for corporate charters? Because they don't charge corporations enough in franchise taxes to really make it economically worthwhile. And the response is, well, you have more businesses incorporated in Texas, you have more work for Texas lawyers. And maybe that's a compelling reason why Texas might want to change its law to make it more business friendly. But I really sense that this is just partisanship on Texas' part. What Texas lawmakers, policymakers are really doing is saying, hey, look at that blue coastal state that is over-regulating and micromanaging its incorporations. Come here where we let you do what you want, what makes sense for your business. So I do think that this has actually become a problem for Delaware that is so closely associated with democratic control. I don't know what you do about that, but I do think that's part of at least the Texas-Delaware dynamic.
Can I interject? So,
Carney versus Adams amendment dilutes that, at least for the judiciary.
Yeah, it attempts to, yeah.
So I'll add just another perspective here. It's not just the red versus blue of the judiciary, of the citizens of Delaware. It's the general populace of shareholders. and they're, because all, shareholders are from everywhere. They're not necessarily from Delaware. And there's a lot of, there's scholarship, there's literature about the shifting balance of the shareholder ownership base, the shift in generations. And there's also scholarship that explains that the younger generations, well, they tend to be a little bit more, less, how should I put it, less, at least according to the literature, less profit motivated and more, additional motivations. And in my opinion, that explains some of the doctrinal drift with regards to Delaware oversight duties. I don't know how in the past it was extremely narrow, I guess you could call it that. You'd have to the board of directors has to make sure that the corporation is obeying the law. And about 5 years ago, there's this expansion, and I guess your friend Leo Strine was partly responsible for that. It's not only the law, it's anything that is mission critical. And in writings, non-judicial writings, he expanded on that to explain that mission critical can be anything, even in politics. And so I think and by the way, there hasn't been many new oversight cases in the last few years. So that, I think that just, might give us an explanation about how much they enjoy dabbing in politics and in the political sphere.
Yep.
I'm a corporate tax guy, finance, so when I'm looking at the market, I'm looking at institutional investors because that's the most substantial shareholder. And those institutional investors for our like teacher retirement system, both local, state, CalPERS, the state, yada yada. Okay. What do they think? Because they are if there's a substantial shareholder but for founders, it's institutions or even BlackRock or 401k, 403bs. What do they think about Delaware versus Texas, approach Texas? But what is their opinion? Because they're the ones who are making the big investment decisions. We're now allocating $3-4 billion.
My sense is they want to stay in Delaware.
Yeah, I mean, we've not seen the exodus that could have happened. I think that more companies are actually considering this. Even that, I think, is an improvement over what, it's been 5-10 years ago of just, Delaware do or die. I think it encourages that modesty that I said in response earlier. But, most businesses, most shareholders like predictability. They prefer a rule that's clear over, no rule at all, even if there's a chance that that might yield a better outcome. So, the shakeup here is good. I'd like to see more of a race, but, I don't know that will actually happen, similar to Robert. And I think it is pretty likely that Delaware is going to win here, but at the same time, at least it should make us think a little bit more about what is corporate law, why we're doing what we're doing, and if you're a judge, being a bit more modest, maybe a bit more fair in terms of the outcomes you're looking at, even if you have somebody who might be a controversial party involved like Elon Musk.
Probably about 2 minutes. Anything else? Anthony.
Yeah, so, is this kind of searching review into, who you associate with, et cetera, in terms of assessing the fairness of a transaction where they're doing like what they did with Musk, is this going to kind of continue? And if so, I guess it seems to me at some point that creates a real tension between the standards being applied corporately and the standards of judicial ethics, because I assume these chancellors have lives and families too and go to parties and circles that overlap, right? And so at some point you start to wonder, well, if it's bad enough to deny his pay package, are you really a neutral judge upholding your oath if, your daughter was at, his opponent's birthday party?
Yeah. The short answer is that public companies obviously have their shares listed on either the NYSE or NASDAQ, and the stock exchange, all the stock exchanges have their own rules about who qualifies as independent. Those rules are pretty clear and they're pretty reasonable, and they have nothing to do with kids' birthday parties. And one of the things SB21 did is it said directors shall be independent if they meet the independence listing of the relevant stock exchange, unless you can make some type of heightened showing to show that they're not. Okay? So I think the kids' birthday parties are now off the table. But have to see how it works out. So that's one of the things SB21 cut back on. All right. Thank you all very much for listening to us. We appreciate it.